SJC-12368, Ives Camargo v. Publisher Circulation Fulfillment, Inc., and another.
When you get down there, can you flip the light on? Thanks.
Mr. Fager, good morning, but why don't you wait a little bit until the clock starts, and then you can start. Now you may proceed. Thank you.
Good morning. Mr. Chief Justice, Associate Justice, may it please the Court. We are here today to address two questions. First, does the definition of an employee contained in the Independent Contractor Statute, General Law, Chapter 149, Section 148B, apply to the definition of an employee contained in the Workers' Compensation Statute, General Law, Chapter 152, Section 14? And the second question is, if that does apply, is this appellant an employee under workers' compensation law and therefore allowed to pursue benefits according to that statute?
Well, along those lines, you probably won't be surprised by the first question, which is that the Independent Contractor Statute, Chapter 149, in the first line has language limiting its application to the Fair Wages Statute, Chapter 51, and, of course, that independent contractor statute, and it only references in subsection D that seems to be a penalty provision, Chapter 152. What's the response to that?
Your Honor, my first response is, under the precepts of statutory interpretation, you have to read the statute as a whole. You can't just read a separate paragraph and say that's what this statute says. This statute as a whole includes 149, 148B, 151, and 152. And if you read the penalties section, paragraph D, the penalties section of 148B, you will see that it was clearly the legislative intent to bring 152 into this statute. Specifically, if you read the language, you will see that not only do they say if you violate 148B, and therefore violate 152, the Workers' Compensation Statute, you are subject not only to the civil and criminal penalties of Section 14 of 152, you are also subject to the civil penalties of 27C, which is the penalty section of Chapter 149. Now, you can see that the legislature put thought to this, because if you read the line above where it talks about the penalties for 149 and 151, it says 27C's civil and criminal penalties if you violate that portion of it, and they amended it and took out the criminal penalties of 27C and just said civil. So clearly the legislature was thinking about what they were doing. They realized that if they brought 152 into it, 152.14 has its own criminal penalties, and so they didn't need to double up on that. Clearly it was the intention of the legislature to bring the Workers' Compensation Statute into the coverage of the Independent Contractor Statute by putting this language in paragraph D.
But doesn't that beg the question, why, if they meant to do it, why didn't they just mention 152?
Well, that's a very interesting question, Your Honor, but I would say that they did mention 152 specifically in paragraph D when they amended paragraph D to bring 152 into it. Because if they didn't intend to do that, it raises the question, how can you write in a violation if it in fact does not apply in whole? How can you violate 152 by violating 148 if in fact 148 does not apply in toto to the Workers' Compensation Statute?
Can I ask, but they only reference section 14, right? In
Yes.
D, they only, and then the one thing that struck me that neither of you have argued is the AG's letter of interpretation in a footnote talks about that the workers' compensation law has its own definition of employee.
Yes, it does.
So doesn't that change things? Because in that same footnote, the AG mentions that the unemployment insurance also has a different definition of employee. So isn't that the answer, that we look for the definition of employee in the particular statute?
Well, I would say yes, except that the definition of employee in 152 is so vague that in fact it leaves it open for the definition of an employee in 148B to be brought in. Specifically, what it says in Section 1.4 is that employees are persons in the service of another under any contract of hire, express or implied, oral or written. So if you have a contract of hire that says you are an independent contractor, but this statute says it's still a contract of hire. You still need to look at that statute. 148B gives you the instructions on how to interpret that contract of hire. Decisions of this court and the appeals court, specifically the Driscoll case, has said you need to look at a contract of hire, go beyond the scope of that contract itself to look at the actual facts of the situation to determine if the person is.
So we, even though the workers' compensation law is, I don't know, 100 years old?
Yes, 106.
And that definition predates by 90 years the independent contractor law. And we've had sort of a longstanding, at least administrative interpretation of the meaning of employee. We ignore all that and move right to this three-part test, even though the legislature doesn't expressly reference all of 152, including section 1 in the statute?
My answer to that is yes, because it was the intention of the independent contractor statute, which was originally drafted, I believe, in 1990 and amended in 2004 when they brought in the language of 152. It was the specific purpose of that statute to broaden the scope of the definition of an employee to extend the protections of the state employment laws to all people who should be covered as employees under the law. As both 148B and 152 have been defined by this court as remedial statutes, they are to be interpreted broadly. They are also to be brought together to work together, if in fact they can, when they deal with the same subject, which in this case is the rights of employees, the right of an employee to be protected under the workers' compensation law should they suffer an injury while
Can I
working.
push you then a little bit? So the unemployment insurance law has a two-part second prong, right?
Yes.
So did the legislature void that second part when it passed Chapter 149?
I don't believe so, Your Honor.
So if they don't displace the UI statute's second prong, why do they displace the workers' comp interpretation?
Because, Your Honor, you go back to the 2004 amendments of 148B, when they specifically said, if you violate the workers' compensation statute by failing to properly apply the elements of 148B's definition of an employee, then you are subject to the penalties of Chapter 152 and Section 27.
But there's, that part of 152 is the part about intentionally misclassifying employees to lower your workers' comp rates, right? Section 14, that was a big concern, that you're structuring your employment right, you're structuring stuff to deliberately avoid the workers' comp laws. So your point is that because of that, we change the definition?
I would not say change the definition, I would say expand the definition. But yes, I think that, in fact, that was the intention of the legislature. That's the purpose of 148B. And yes, when you combine these two remedial statutes to protect the rights of people who are working for others, to define them as employees, and then give them the protections of the employment laws, not only workers' comp, but all of the others.
But then back to Justice Budd's and Lowy's question, and Justice Lowy's question then, why isn't all of 152 referenced in the first sentence? Is that just a mistake by the legislature?
I can't answer for what the legislature was thinking, Your Honor. That's an interesting question. I wish I could reach into their minds and give you an answer for that.
And
But I
we
will
don't have
tell you,
any legislative history on this?
the only legislative history, as you know, Massachusetts legislative history is often lean. And the only legislative history, as pointed out in the amicus brief, was around paragraph D and amendments thereto. And it was their opinion, and ours as well, that it was the intention of the legislature to bring 152 in toto into 148B for purposes of defining an employee.
And from what I understand, the governor vetoed one of these provisions, and then it was overridden. It's not, is that the original statutory provision, or is it a supplementary one? Because this is passed right in December of '89, right? Right before there's a change in administration, and then someone vetoes it?
Yeah, I really don't know the answer to that, Your Honor.
If I can go back to the practical consequence, let's turn to 2004.
Okay.
At the time that the legislature is contemplating this. There is a separate statute that defines an employee, I gather, with regard to unemployment compensation, not referenced in this statute, but I gather it's nearly identical to the definition here, correct?
Yes, it does. It has a three-part test of defining an employee.
So you're not likely to have an employee who is an employee for purposes of wages and for purposes of overtime, but not an employee for purposes of unemployment compensation.
That's correct. You're not likely to have that.
So now the question is, you're an employee for purposes of wages, you're an employee for purposes of overtime, you're an employee for purposes of unemployment compensation. And why would the legislature contemplate that you would have a different characterization when it comes down to you're getting injured in terms of workers' compensation? I'm trying to think if there's any reason why they would, trying to get into the head of the legislature in 2004.
Your Honor, my answer to that is that the legislatures, what they were trying to do in 2004 was in fact, I would say correct rather, an erroneous definition of employee they made in 1911 when the workers' compensation law was first passed. Perhaps at that time the idea of independent contractors was not one that was fully formed and one that employers would use to avoid the workers' compensation law. But as time has progressed, clearly that has become more and more of a part of the workforce, and it was then the attempt of the legislature by creating this penalty section in 148BD to bring 152 into the tenets of 148B and say, this is how you define an employee. This person is covered under the wage and hours law. She should be covered under the workers' compensation law. And this is what we were trying to do by amending this paragraph of this statute.
So let's imagine an employer acting in good faith, in keeping with the law, has somebody who, in a different state, arguably would be an independent contractor, but sees what the definition is and says, okay, I'm going to pay you a wage and I'm going to pay you overtime, and if you're unemployed, I'm going to pay you unemployment compensation. How would it would be illegal for them not to provide workers' comp insurance if they were an employee, I gather, correct?
Under that hypothetical, absolutely, yes, they would be in violation of 152.
But if they're right and you're wrong, the employer could say, well, I'm not going to provide this person who's otherwise an employee with insurance because under the workers' compensation law, you're an independent contractor.
Well, Your Honor, if that is true, then you have a glaring injustice to the employee and all people who are working as employees and classified as independent contractors. You are covered under the wage and hour law. You are an employee for purposes of the wage and hour law and the unemployment compensation law. But if you get hurt at work, you are not an employee for purposes of the workers' compensation law. Then you have before you, as I said, a glaring injustice to that person. You can apply for all of these other things, all of these rights of employment, but if you get hurt, you're on your own. And that was clearly not the intention of the workers' compensation law when it was passed over 100 years ago. And I believe by putting in the penalties sections in paragraph D of 148B, the intention of the legislature was to say, wait a minute, if you do what your hypothetical just said, you're violating 152, and you're subject to the penalties of 152, and you have violated 148B, and you're therefore subject to the penalties of 27C of 149, well, the civil penalties, not the criminal penalties.
Just playing it out, I mean, the employee who is then accused of not providing workers' comp to an employee who otherwise has treated this person as an employee would then have to say, well, yeah, I treated them as an employee for purposes of wages, but under the common law with regard to workers' comp, or under the interpretation of the workers' comp law, it's different and they're not, and So you'd have this strange world in which I'm treating you as an employee, but yet I'm not treating you as an employee for one purpose.
Well, Your Honor, I would say this. The Workers' Compensation Trust Fund would then become the insurer of note for that employee because the employer does not have workers' compensation insurance. The Workers' Compensation Trust Fund would then pursue penalties against that employer, civil and perhaps criminal penalties, but also reimbursement. That is, they would recoupment. They want their money back. They paid benefits to this injured employee who this employer did not define. They would then seek recoupment. So, yes, there are ways to recover and provide that person with their benefits. But I think the purpose of this amendment was to bring this whole statute in so you could objectively look at the facts of a case and say, yes, this person, according to 148B, should be classified as an employee and therefore entitled to workers' compensation benefits.
Can I? Sure.
Before you run out of time, so that you can have a chance to respond to an argument that you'll hear on the other side, just moving a little bit away from statutory construction for a moment, if we look at the key McTavish factor and the one of the factors in Section 158 dealing with exercise of direction and control, what's your response as to why your client is an employee and not an independent contractor when you apply at least that McTavish factor?
Your Honor, I would say the answer to that is what this employee was required to do under the direction and control section of 148B. She was required to deliver by a certain time every day. She was required to deliver to a list of subscribers provided by the employer. She did not own the routes on which she delivered. She did not own the papers that she delivered. She did not collect any money from these people to whom she delivered papers. All of this was done by the employer or the employing unit. So she was absolutely under their direction and control. She really had no independent role here. If she was an independent business person, she would have gone out and established these routes, cultivated the customers, collected the money from them, purchased the papers from this distributor. None of that happened. It was all done under the direction of the employer.
Can I follow up on one of the Chief's questions, though? There is, in unemployment insurance, that second prong can create differences, can it? I mean, in even this case whether this person would be eligible for unemployment insurance might depend on whether there's two parts to that second prong, right?
Right.
So we would have inconsistencies even under the UI statute, right?
Yes.
So the whole thing's a mess in certain
Well,
ways.
it is important to note that the reviewing board on page 11 of their decision said that if 148B in fact applied under the second prong, she would have been found to be an employee. But in their opinion, this statute did not apply, and therefore they didn't find her to be an employee.
But I assume that if you were to prevail, we'd have to remand it to them for that determination.
Yes, I would ask that you remand this back to the Department of Industrial Action for the determination. Well, I would presume that this panel would decide that she is in fact an employee and entitled to workers' compensation to apply for
So
workers'
I'm
compensation
trying to figure out what you are asking us to do. I understand that at a minimum, you're asking us to say that the definition in 149, Section 148B should apply. Are you also asking us to apply that definition to the facts here and make a factual determination, or is it your view that we should remand it back to the board for it to make that determination?
I would say, Your Honor, I'm asking that based on the facts found in this case and contained in the record of this case, that there is sufficient evidence for you to find that she is in fact an employee when you apply the elements of 148B. And then you would remand the case back to the Department of Industrial Actions to find out, to determine if she is in fact entitled to benefits.
Now, even though I think it was Judge Bean had some certain credibility determinations that he seemed to make?
Yes. But he never said she was not injured while working. So, yes, there were credibility issues raised at the trial, and those would be raised again at a remand before Judge Bean. But I would assert, Your Honor, that The ultimate question is whether or not she was actually hurt at work, and that was never in dispute.
All right, thank you.
Thank you.
Mr. Kelly.
Good morning, Chief Justice. Good morning, Justices. I'm Paul Kelly, and I represent PCF. I'm accompanied by Bruce Barker, also representing PCF. And at the outset, I'd like to start by answering a couple of the questions that were asked. Chief Justice talked about getting in the head of the legislature, and Justice Kafka indicated that you wanted to understand the legislative history. And I have some information on that. In that context, the legislation started in 1990, and it was strictly a wage statute. It was really about wages, and Chapter 149 was the strict scope, as was noted by Justice Lowy and others. When you go forward, this statute was amended in the 2003 and 2004 timeframe. And in that timeframe, the first thing that occurred was the House of Representatives brought forward a bill to add Chapter 151, which added a statute section, and implicitly in that context, they are indicating that they knew that they needed to add a section to have it included. If they wanted to include Chapter 152, they could have said, and include Chapter 152. When you go forward to 2004, the act that was brought forward to the Senate was called an Act in Further Regulation of Public Construction. That was the focus of the legislature at that time. We've listened to the Senate tapes. Senator Wilkerson, Senator Tolman spoke at length about the objective at this point in time was to rein in public contractors and to impose stricter regulations on them. My interpretation of this statute is that you have threshold regulations under Section 149, 148B, Section A, that apply globally. It does not in any way change how employee-employer versus independent contractor relationship is defined under Chapter 152. The second part is a penalty clause, Section D, and that is the further regulation that was imposed in the context of public construction. When you look...
But I don't follow that, though. I mean, the Chief Justice's question, you're going to have two different workers, you're going to have two different rules applying in the workers' comp laws? How's that going to work as a practical matter? Why would it reference Section 14, but not apply to employees? I just don't understand how it works. What would the logic of that be?
What you have, the threshold part of the statute, Section A, simply works on wages and those types of things. Mm-hmm. When you look at the penalty clause...
So meaning that, for example, this woman would be entitled to be paid a minimum wage?
Correct.
Even though she wouldn't be... So they could set up an independent contractor relationship, but she still would need to get paid the minimum wage? Is that how it would work?
She would have to be determined. If you were dealing with a minimum wage issue, you would have to make the determination under 149, 148 to determine whether the individual was an employee or an independent contractor.
So even though she would be a contractor, an independent contractor for workers' comp purposes, she would be an employee for minimum wage purposes?
She might be, but she might not be.
And let's just play this out a second.
Sure.
And she could conceivably also be entitled to unemployment insurance under this three-part test, but not entitled to workers' compensation under the 10-part test of the workers' comp laws?
That is a possibility, but I think when you come right down to it, when you are looking at...
But let me go further.
Sure.
And also, the employer, what is the... Section 14 is a very important provision, right? Because you don't want people misclassified. So what did they mean in the sentence in D then? So why would you look at this 149 provision to determine whether someone's misclassified when you're going to still consider the 10-part test to determine whether you're an employee. What's the logic of that?
I actually think that when you look at, when you're looking at whether someone is an employee under Chapter 152,
Right.
you just look to the McTavish test and the restatement test, and you look to the SJC precedents where right of control was brought up in 1931. That's in play here today. You also have the burden of proof with respect to workers' comp, which was set in
But
1950.
your brother is arguing that the legislature changed all the rules of the game for everything.
And
They
I
did that.
disagree.
I understand you disagree, but
Yeah.
there's a simple logic to what he's doing, which is saying, for everything, we apply this.
And the legislature, if you look at the legislative history, and if you look at the title of the bill, if you listen to the Senate hearings, and you listen to the speeches, the intent of the legislature when they went to 149,
I get that, but what I'm trying to, because I unfortunately spent a lot of time on workers' comp at one point. So you're going to have to.
so do I.
You're going to have to, you're making a big determination whether somebody has to be classified as an employee or not because of the leasing issues in workers' comp, right? That's a big deal whether you're accurately listed as an employee versus an independent contractor, right? Because it affects your workers' comp rates, right?
It would affect.
And that's what Section 14 is about, right?
Section 14 is really about, it takes into account if someone has a knowing misclassification.
Right, but that's what I'm trying to understand. So are they saying that we apply this 149 provision for knowing misclassification? What does
No,
that sentence
that is-
mean?
That is not saying, it is not saying that at all.
What does D say then?
What D is saying, it is adding further regulation to regulate public contractors. And when you look at D,
That can't be right, though, because there's nothing in there that just talks about public.
but if you look at the title of the bill and if you listen to the Senate, that gives you an indication of the legislative intent. The legislative intent, as you've indicated from strict statutory construction, only encompassed 149 initially. Then when it was amended, only 151 and 149. It never said 152. And there was never anything in the legislative discussions about changing the concept for workers' comp and how you're going to define employee versus employer relationships. That was not the subject matter. The subject matter was,
I know, but we don't consider titles when we interpret legislation. And just because a couple of senators start talking in the debates, we look at the actual language. So I'm just trying to get a sense of how we make sense of that language about Section 14. Do we apply a different test to Section 14 than we do for the rest of 152? Do we apply a different standard there?
no, you do not apply a different standard. The employee-employer standard is still determined under Chapter 152.
So McTavish, whatever it is, applies in D then. In Section D of the statute, when they reference the workers' comp, all they're referencing is the 10-part McTavish test, even though the statute that's referencing it has a 3-part test that's different?
No, what I see in Section D is that when you're interpreting it, you still have to keep in mind the context of what the legislature was trying to accomplish, which is impose penalties on public contractors.
Is the word public contractor anywhere in Section 14?
No, but if you're going to look for the legislative intent, the words of the senators come into play. That was the issue. But even when you start to look at this statute in and of itself, the reviewing board got it right. You need to have a misclassification and a second bad act to trigger a remedy. And so the word "and" in so doing is really in addition. We've looked up synonyms, and it's in addition, and this is one interpretation of it, is and in addition, or moreover, further, and et cetera.
Although the actual language is in so doing, right?
Correct.
And it references 149, doesn't it? Doesn't reference
In
McTavish.
the first sentence, if you take that in isolation, You're looking at whoever fails to properly classify an individual, that's A, and then you would need a violation of wages, et cetera, and that would be B. You need A
Yeah,
and B.
you forgot
I know.
something in A.
What's that?
You forgot something
Oh, I
in
know,
A.
but I can.
It's whoever fails to properly classify an individual as an employee according to this section.
I know, and
So the issue is, why did the legislature say according to this section, referring to section 148B? It didn't say according to McTavish, it said according to this section.
right, and in this section, you're talking about a penalty clause section, is how I read it, and that's how I interpret it. That you have a penalty clause that is being applied in the context of, that's in public construction. When you look at it, you've
I'm sorry,
got
which section are you saying, when they say according to this section, which statutory section are you saying they're referring to?
I'm saying that it applies to 148B, Section D, that section. Because when you look at it,
That's a subsection.
but it's still, in this context, that is the legislative intent.
Now, you haven't done too well, or that argument hasn't fared very well. We've got two Superior Court cases, I think Judge Sikora and Judge Curran. Then you have a First Circuit case, and I know it was only dicta in the Travelers case, where the interpretation has gone the other way. And I can't remember the name of it, but there's also sort of an inscrutable 128 case as well from the appeals court that seems to go the other way. So there might be some argument from Judge Muse's decision, but it seems that the decisions about this discussion of subsection D are different from your view.
Actually, I'd make a couple of points on that. First of all, in the Superior Court cases, they actually add 152 in their language as if it was in the statutory language, which it wasn't. In the federal court First Circuit case, in that case, the federal First Circuit actually truncated this honorable court's qualifying clause, where you have repetitively indicated that it's for the purposes of the wage statutes, and they just left that off and then went and applied it. I think it's misapplied by both the Superior Court and the First Circuit. And if you look to the Camargo case by this court in 2015, you have a subsequent decision in the context of taxi cab drivers, and this court indicated that since taxi cab drivers were excluded from the Workers' Compensation Act, that you would therefore use 149, 148B to make a determination whether they were employees or independent contractors as being excluded. Therefore, you're going to use this other statute. But by negative inference, if they weren't excluded, this court has effectively ruled that you would use the normal McTavish factors in case of Strong and the list of factors from the restatement. So implicitly, in your decision in Camargo, you've trumped any prior Superior Court decisions, and those Superior Court decisions are all predating your decision in Camargo, in the Camargo case.
Attorney Kelly, are you familiar with, I think there was a proposed bill introduced in January regarding newspaper carriers. Are you familiar with that?
I am not familiar with that.
Okay, it was Senator Lovely has introduced in January 2017 an act regarding the status of delivery persons. It's 2017 MASD 1568. It's obviously not passed, but it says Chapter 149, Section 148B of the Mass General Laws is hereby amended by adding a new paragraph F to read as follows, and then it goes and discusses when newspaper delivery persons shall not be considered employees under this chapter, meaning 149, Chapter 151A or 152, and then they discuss three different factors. These factors are whether the person's engaged in the trade or business of delivering newspapers, substantially, or shopping news, substantially all the remuneration for the performance of services is for services rather than hours, and that the services performed by a person are performed pursuant to a written contract. Would that, if that were passed, would that change your argument in any way or assist you, or? your argument?
Well, I think it's too, I think obviously I would say that it's too early. At this point, we don't know where it's going to go.
Right.
But the reality is that when you look at these types of cases, you look at the contract for hire, and then you look at the facts and you apply them, and you look at not only what the contract says, but how they operate.
Well, as we could divine maybe legislative intent by listening to the hearings, does this give us any suggestion regarding intent?
I don't think that
ability?
it's, I don't think that it governs in any way how this is determined.
No, I don't think it governs, but it could be a clue.
What they do in the future is a crystal ball, and who knows, I appreciate your point, but at this point in time, that is not the state of the law. Justice Lowy, did you want me to comment on why I think this person, did you want me to?
Well, sure, I expected that you were going to. So if you take this case.
Yes.
And you apply the McTavish 10 factors, and perhaps even use the 3 factors from Section 148, why are we dealing with an independent contractor as it relates to this newspaper delivery individual as opposed to an employee?
I think earlier this morning, you mentioned that credibility was an issue. There was a major undercurrent on this case, as you know, which we've let go, even though we don't agree with that decision that it's not constituting fraud. And moving forward, the judge specifically ruled that the testimony of Ms. Camargo would be rejected as not credible any time that there was a conflict between her testimony and the testimony of the PCF witness. The PCF witness established, and we established through documents, that there was a contract, that this individual came and just picked up the newspapers and could do whatever she wanted. She also had assistants helping her on the weekends, according to this witness. She hired substitutes to handle this job. Those are things that employees can't do. They can't, bring in their sister to do the filing today. It just can't happen. But she had control. And she had taxes that she was articulate and intelligent enough to file and not show any income by writing off her income through her expenses as an independent contractor for many years until there was an injury and now she wanted to be an employee. That's how we viewed this, is that as you go forward, the ability to subcontract, the ability to hire assistants, and the fact that when the witness was asked, our witness, would you supervise? He said there's no need to, because basically you had a contractual provision that just said that someone had to deliver papers by a certain time in reasonable order. That's basically the gist.
Respectfully, I don't get it.
Well,
Let me I'll ask the question, then I'll give you a chance to
Sure.
answer. You bring in individuals, many of them immigrants, because they're up at 3 o'clock in the morning to deliver newspapers, and you basically say you're being hired as an independent contractor, and you sign an agreement which says you're an independent contractor. And so, of course, the employee, the person, even if the person may or may not, may be an employee pursuant to 148B, is going to say, I've been treated as an independent contractor, and of course is going to apply, it's going to act as independent contractor because that's the agreement that she signed. So if you were wrong to force her to sign that agreement, how can you possibly use the fact that she then filed taxes as an independent contractor to say, aha, she acknowledges that she was an independent contractor because you made her couldn't start the work until she signed the agreement that said she was.
Well, I don't think that she was forced to sign anything. It's a choice.
It wasn't forced, obviously, but she couldn't, she wasn't able to get the job unless she signed.
And it was not a job. And the testimony.
The task. She couldn't basically begin to earn money delivering newspapers.
No, I disagree, Judge. I respectfully disagree.
Really? You said you can...
She delivered papers for the Lowell Sun, which has nothing to do with our operations. Zero.
But in terms of delivering papers for your operation, a condition of her being permitted to deliver those newspapers and get paid for it is she had to sign the agreement, correct?
They were not going to enter into an agreement, but you also have the Cape Cod Times has the exact same agreement.
It may be that others have it, but I just don't know why you can sort of say that when you require somebody to sign that agreement as a condition of commencing work, I don't know how you can then piggyback and say, well, then she filed taxes as independent contractor, and then she acted as independent contractor to say, I was right initially to force her or to require her to, as a condition of her commencing work, to characterize herself as independent contractor. That's the problem I have with your reasoning.
Well, I think that there's nobody that's forcing anybody to do anything. This person made a choice she was already delivering for the Lowell Sun. She's expanding her business. She could deliver other products. She could deliver pizza. She could deliver flowers. One of the witnesses actually talked about that. And I think Judge Bean actually talked about that. There are a lot of different things that this individual could do. And it's not that she wasn't constrained to this company to operate, because there are other companies like the Boston Herald is another, and you've got papers on the North Shore that, other than the Lowell Sun, that she could have engaged in. And I look at it as it's akin to, like an electrician can get a number of different jobs and accumulate an ability to earn income and order their business relationships in the world, as opposed to being constrained to this. If she was constrained, and this was the Boston Bicycle case is along your lines, I think, in the sense that the practicality was that they were courier deliveries, and they really couldn't find any other alternatives. And that may be a different case, whether we agree or disagree on the case, but the bottom line is that there is a distinction, that this individual had a right to choose whether she sought out the ability to do this, and in that context, took advantage of all the trappings of, if you want to call it trapping, I don't know if that's the right word, but of independent contractor status, by being able to not work on a Saturday, have someone else do it, by delegating, by having assistants come in. If it's operated correctly, you have the ability to expand, like the Cape Cod Times, which is like 6,000 newspapers. And back in the 90s, when I was dealing with this in the context of community news dealers, which became PCF down the line, there was one individual that opened up in his territory, opened up something at one of the train stations. I mean, it is an entrepreneurial opportunity if you look at it in one context, as opposed to framing this individual as a victim here. I don't think that's an accurate assessment in my view, and I respectfully.
Okay, good. Thank you.
Thank you.
All set?
Thank you.
Thank you very much for the opportunity.